want to say that I've long prized Professor Keshler's insight and conviction that genuine intercultural dialogue is essential for each culture to define better its own identity, understand and respect other cultures, and promote international cooperation and world peace. And I salute the forum's far-sighted diplomatic leadership for promoting dialogue among civilizations, which is an ever-urgent goal in an ever more turbulent world. It's also a pleasure to be back in Greece, as always. I will focus on humanitarian intervention, how it has been abused or used, and its connection to the responsibility to protect and regime change. I will focus on what is humanitarian intervention. Sorry, let's get right to the main part. Suppose state A perpetrates, or is clearly just about to perpetrate, serious human rights violations, such as genocide or crimes against humanity, against its own citizens. Does international law allow another state, state B, to intervene militarily in a territory of state A to protect the nationals of state A from being wiped out by its own government? We're not talking about intervening state B protecting its own nationals, but rather the nationals of another state, which is state A, from its own government. Humanitarian intervention refers to military action by one state against another state purely on humanitarian grounds, not to protect its own nationals or its own interests. For intervention to qualify as humanitarian, it therefore must be devoid of self-interest, according to the doctrine. Otherwise, it is intervention for other reasons. Humanitarian intervention, properly so-called, again, refers to military action taken outside UN Security Council or regional collective security arrangements, and its origins actually predate the United Nations Charter. Humanitarian intervention should not be confused with UN peacekeeping missions or humanitarian non-military assistance, such as food drops or vaccination campaigns. Humanitarian intervention, whether exercised individually or perhaps jointly with certain other states, represents unilateral use of military force in the territory of another state without that state's consent on purely selfless humanitarian grounds. Whether or not humanitarian intervention is lawful is a very important issue, because where UN collective security arrangements are blocked and fails to stop the violence, whole communities can be severely traumatized, if not eliminated entirely. Maybe humanitarian intervention can save lives. 20 years ago, I saw what can happen to people when UN collective security fails and violence is unchecked. In October 1994, just a few weeks after the Rwandan civil war ended, the UN deployed me to Rwanda to investigate the genocide and associated violations in support of the UN Security Council's Commission of Experts, which was formed by the Secretary General Boutros Boutros-Ghali on 1 July 1994. I journeyed through Rwanda by road and helicopter to investigate massacre sites with a Spanish forensic team, interview witnesses, collect information, prepare the Commission's reports on facts and responsibilities, including recommendations on what should be done. It was a shocking experience, to say the least. In only 100 days, between 6 April 1994 and the end of June 1994, elements of the Rwandan army, together with extremist Hutu militia, slaughtered between 500,000 and 1 million, mainly Tutsi and moderate Hutu civilians throughout Rwanda. The numbers are very broad because it's difficult to ascertain with great precision how many people were killed. I was quite horrified to see not only the extreme violence, an enormous number of victims, but that the victims were not armed. They were defenseless civilians, men, women, pregnant women, children, and babies. I didn't take these pictures because I didn't have a camera at the time. I didn't own a camera, but my colleagues did. This is the scenes that we saw. It's pure carnage, bodies upon bodies and bodies. It was a brutal slaughter of civilians rather than combat deaths. Everywhere we went, we didn't see combat deaths. They were not soldiers and militia forces. It was a slaughter of civilians. And the violations clearly constituted genocide as defined in the 1948 UN Genocide Convention, crimes against humanity, violations of Article 3 common to the 4 Geneva Conventions, 1949. We collected information and received information from the usual suspects: governments, UN agencies, bodies and programs, other intergovernmental bodies, both sides to the armed conflict, the International Committee of the Red Cross, non-governmental organizations, private individuals, including witnesses. We went personally and interviewed people. Forensic investigations, massacre site exhumations, examination of bodies, documentary evidence. The evidence was very clear that extremist Hutu militia tried and partly succeeded to exterminate the Tutsi minority in a methodical, let's say, to quote the reports to the Security Council, in a concerted, planned, systematic, and methodical way. And the motivations were ethnic hatred. It's very, very clear from all the information we received from a huge array of sources. We also found that the insurgent Tutsi-dominated Rwandan Patriotic Front carried out violations and massacres. These were far fewer, much smaller number of victims, far less systematic than those of the Rwandan government armed forces and Hutu militia. Now, the international community's failure to stop the genocide was entirely shameful. If you look back in history, the Nuremberg and Tokyo trials following World War II were quite flawed. The ICTY and ICTR are far from perfect. I myself have criticized quite a lot these ad hoc tribunals, and some of the criticisms that have been already stated are valid. Others I would disagree. But they're not perfect by any means. But the Nuremberg and Tokyo trials gathered and produced detailed documentation, which at least make it harder for revisionists to claim the Holocaust never happened, or claim Jews were not victims of genocide, or to equalize responsibilities between Axis and Allied powers. The Allied powers committed violations, very serious ones. What about the bombing of Hiroshima and Nagasaki? What about bombing of Dresden? There are big violations. These were very one-sided tribunals. But that doesn't mean that their responsibilities were equal in all respects, or that there was not an aggressor, or that one side was not more to blame than the other. It makes it more difficult to distort facts, spread falsehoods, and develop twisted conspiracy theories that have no basis. Conspiracy theories are very hard to rebut because you have to prove a negative. There are conspiracies. Conspiracies take more than one person. You have a conspiracy. But the conspiracies are often so ridiculous that they don't make any sense. They don't jive with the evidence you find in the field from as many sources as possible. Similarly, in Rwanda, ID cards from the bodies of victims, witness testimony, documented meticulous planning by Hutus of Tutsi massacres, which were warned about actually as early as August 1993 by Bakary Njai, Special Rapporteur on Summary Executions, to the Commission on Human Rights, which is now the Human Rights Council. It was ignored by the international community at the time. There were signs of all the planning going on before the genocide. Mountains of other evidence make it more difficult for today's Hutus extremists or their friends to deny or minimize responsibility for the 1994 Rwandan genocide. Now, I'm talking about the 1994 genocide. I'm not talking about the slaughters, and maybe that, that have occurred of Hutus by Tutsis, that have happened before or afterwards. And, for example, in DRC, we don't have a tribunal. And there are reasons one can debate about that. And the government of Rwanda has got lots of blood on its hands here, there, everywhere, because it's been involved in conflict and for other reasons. But the civil war itself, it's very clear from the evidence that we reviewed, that we received. Now, if another state had intervened militarily in Rwandan territory to prevent the genocide in 1994, without the government's consent, and for no reasons other than humanitarian purposes, would this have broken international law, even after UN collective security had failed and no other options seemed available? Mahatma Gandhi, who, Mahatma meaning great soul, might have advocated satyagraha, truth forced through voluntary suffering in the face of tyranny, as the answer in Rwanda, just as he counseled the Jews in Nazi Germany to employ passive resistance only. But as philosopher Martin Buber pointed out in his open letter to Gandhi, Jewish passive resistance in Germany had no positive effect whatsoever on the Nazis. Not true. In the face of the kind of tyranny that you had in Nazi Germany, or in Rwanda for that matter, passive resistance would be very effective. Now, if purely peaceful measures have little chance of deterring a government from massacring its own citizens, and collective security remains blocked, military intervention on humanitarian grounds sounds perfectly legitimate, especially if it offers a way to prevent the kind of genocidal carnage, the aftermath of which I witnessed in Rwanda. Could we even go further and argue that states should not just be permitted to use humanitarian intervention, they should have a legal obligation to intervene rather than just to stand by and do nothing while helpless civilians are massacred? Well, we have to be very careful because war inevitably involves death and destruction, regardless of how righteous sounding may be the justification for it, or how dire the threat may be. And the real proof of any doctrine is not in its intentions, but in its practice, because the road to hell is paved with good intentions. before considering humanitarian intervention in practice, let's check first what the UN Charter says. Article 2.4 says all members must refrain in their international relations from the threat or use of any force, etc. Article 51 preserves the inherent right of individual or collective self-defense if an armed attack occurs. A plain reading of the UN Charter allows for the use of force only with regard to self-defense or by the UN Security Council insofar as necessary to maintain international peace and security if an armed attack occurs, not on grounds that it might occur, and only until such time as the Security Council takes measures to maintain international peace and security. Few states claim the customary right to preempt an imminent attack, but this is another issue. The UN Charter thus clearly prohibits the use of force by any state against any other, ruling out any form of unilateral humanitarian intervention, since humanitarian intervention is military action by one state against another, not for reasons of self-defense, but for humanitarian purposes. And according to Article 39, it's the UN Security Council's obligation to maintain or restore international peace and security. And we have Articles 41 and 42, which authorize all sorts of wide-ranging measures, including military force, to this end. I won't go into some of the more detailed, subtle arguments, which one can read from things I've written or others have written. And for the interest of time, I will cut some of those arguments, because I think, how far are we along? 10, 12 minutes? Only 4 minutes? So, okay, I will cut it. The real problem is, it's not in the UN Charter so much, but in the use of Security Council permanent member veto, which blocks effective council action to stop a government from committing genocide. Since Chapter 7 enforcement action requires 9 affirmative votes out of the 15 council members. For most of the history of the United Nations, the United States has vetoed Security Council action with regard to prevent Israel from committing serious violations in the occupied territories. Soviet Union vetoed all sorts of Security Council resolutions. So have the other permanent members to protect their narrow self-interests. More recently, we have vetoes from the People's Republic of China and the Russian Federation with regard to Syria in October 2011, February and July 2012, calling for the Syrian government and all other parties to cease all armed violence. And in May to block a resolution to refer the situation to the ICC. Meanwhile, the death toll in Syria has gone from a few hundred in March 2011 up to over, approaching 200,000 as of end of August. Where did humanitarian intervention come from? It's an old doctrine. I just quickly mention Cicero, St. Augustine, Aquinas, and Ambrosius. It's been developed over time. It was claimed in regard to by France, Great Britain, and Russia to justify joint military action against the Ottoman Porte on many occasions, including the Crimean War, Bulgarian uprising, the 1915 treatment of Christian Armenians. The problem is that intervening states clearly had strategic, political, economic motives, casting serious doubt on their claims of humanitarianism. Even Hitler found humanitarian justifications could be useful. In highly inflammatory speeches and radio broadcasts, Hitler claimed that German ethnic minorities in foreign lands needed protection from the persecution of their own government. So he snatched first the Sudetenland and then all of Czechoslovakia. And can you imagine if every government decided it could use military action in other countries to protect people living there who happen to share its own majority culture, ethnicity, religion, or language? What would that do to sovereign independence and territorial integrity of the subject state, to international peace and security and the international rule of law? I'm going to start to wrap up quite soon, so not to worry. More recent candidates, and they're, just to mention quickly because it's too detailed for the time we have, one of the good, more plausible candidates for genuine humanitarian intervention was the intervention of India in Bangladesh in 1971 during the Bangladesh Liberation War. Because India made a fairly quick intervention only after collective security was blocked. A lot of atrocities had already been committed. They sought no territory. They withdrew troops very quickly. But even in that case, which is a strong case for humanitarian intervention, India had a definite strategic interest in weakening its rival, Pakistan. And moreover, India even switched its rationale, its justification for military intervention in East Pakistan from humanitarian intervention to self-defense. So it's hard then to argue on India's behalf that your real reason was not self-defense, it was humanitarian intervention. I know time is running, so I will just mention two other cases, which are Tanzania, and without going into the details, where again Tanzania had very clear strategic motives as well as humanitarian motives for going and deposing the Idi Amin regime. And Vietnam, in intervention which brought the regime of Khmer Rouge to an end. Still there you find all sorts of other interests. And just to speed along, invasion of Iraq. Well, the motives there were weapons of mass destruction and removal of Al-Qaeda, which was clearly not present in Iraq at the time. And also the violations of Saddam Hussein's regime over time, which were real atrocities. But the first two motives, for sure, were very flimsy, and a lot of us said so at the time. And so did governments, so did the United Nations itself, the Secretary General. So my question is, this is Libya also is a very problematic case because it's given way to more violations after regime change, and the country is extremely unstable, and you have a highly unstabilized situation. I won't go into, because I only have a minute or two. It's okay. I will not go into the R2P. I only want to say, just to wrap up, that as long as, let me just skip through this. 30 seconds. As long as, if we're going to recognize humanitarian intervention as part of international law, which is what its proponents have been putting forward, then it would have to apply equally to all states. But would we really want North Korea, would the United States, United Kingdom, Russia, France, and the UK want North Korea, Libya, Sudan, countries that it doesn't trust, to say, well, wait a second, we're going to intervene in your territory because we think we're the ones that make the decision, and it's unilateral appreciation of the facts. Obviously, there's a problem with that. Or is it meant only for the richer, more powerful states? In which case, it really has no place in international law if it's not supposed to be for everyone equally. So my last statement would be just to say that let's hope it does not take a third world war to marshal the political will to reform the United Nations structure and to reform the veto power and to rediscover the political resolve that countries seem to have lost since the Second World War to save succeeding generations from the scourge of war. I think my time is over, so thank you very much. I tried to cut some of that. Thanks very much.